Good evening, NY14. My name is Deepa. I'm with the Office of Congresswoman Alexandria Ocasio-Cortez. Thank you for joining our webinar, New Rules, Risks, Relief, Managing Student Loans Now and into 2026. Just a few notes of housekeeping. Please use the Q&A feature to submit your questions throughout the presentation. We will prioritize questions from constituents, so please mention your neighborhood when submitting your questions. Otherwise, you can email your questions to aoc.townhall@mail.house.gov or call 718-662-5970. Our staff is also available to support any technical difficulties. Our team members will be monitoring the inbox and phone. Please note that the information provided in today's webinar is not legal advice or financial advice. Each person's financial status is unique. Please also note that some of the rules we will discuss today are subject to change. If you have any legal questions or questions about how these principles apply to your specific finances, please consult a professional. In today's webinar, we will review the following important updates: existing strategies for tackling student debt and repayment options, income-driven repayment forgiveness, IDRF, public service loan forgiveness, PSLF, IDR guidance for borrowers, total and permanent disability, TPD discharge, delinquency, default, and collections. At the end, we will have a Q&A session, so please note that we will not be able to provide individual legal or financial advice during this presentation or in the Q&A. Now it is my privilege to introduce our co-sponsors, the Community Service Society of New York. We are joined by Nancy from the Education Debt Consumer Assistance Program.
Thank you so much, Nipa, and thank you to Representative Ocasio-Cortez and her staff, as well as the EDCAP staff, for helping to put this event together. I want to start out by telling you a little bit about our program, the Education Debt Consumer Assistance Program. We are a program initiative of a nonprofit called Community Service Society of New York, or CSS. CSS has been operating in New York for over 180 years, and the EDCAP program was created in 2019 specifically to address the issue of student debt, which is a nationwide crisis and a crisis in New York State. Student loan debt is the second largest consumer debt next to mortgages. In New York State, there are about 2.4 million borrowers who hold about $96 billion worth of federal student loan debt and probably another 7 or 8 billion in private student loan debt. And the program was really set up to because number one, the size of the crisis is large, and because the system is very difficult to navigate. And it requires individual one-on-one counseling to help people basically navigate through this very difficult and complex system. And what we do with our network of community-based organizations around the state is we can provide free and unbiased advice for almost every stage of your student loan needs. So starting from helping people understand how to fund higher education, to requesting financial aid and helping borrowers fill out FAFSA, TAP, Excelsior applications, and to managing your debt once you're done with school and all the different things that you may need to do, including choosing the right repayment plans, figuring out what forgiveness programs you may be eligible for and enrolling in those programs. We can help you with all of that. We are New York State funded. Our service is for New Yorkers, and it is, again, our services are all free, like these webinars, plus our one-on-one counseling services. Next slide, please. So today we're going to be spending most of the time talking about the new rules that are coming into place as a result of what we call the OBBBA. This is the One Big Beautiful Bill Act, otherwise known as HR 1. This is essentially the new tax and spending cut bill that was signed into law on July 4th. The new bill is going to introduce some sweeping changes to the student loan system, including new borrowing limits, new repayment options, changes to IDR forgiveness, and we'll talk a little bit more about what that means, elimination of short-term relief programs for certain borrowers, And like I said, we're going to go into a lot of detail on this going forward. The one thing that I do want to make clear from the outset is that the bill itself does not alter the Public Service Loan Forgiveness Program, PSLF. This is a program that forgives your debt after making 10 years of qualifying payments, but there are employment requirements attached to this program. The bill is really not focused on public service loan forgiveness. There is something called the negotiating rulemaking process, which is currently underway at the Department of Education, that may impact which employers are eligible for PSLF going forward. But that's still in process, and any changes to PSLF at the earliest would happen next year. Next slide, please. So one of the things we're going to talk about is the end of the SAVE plan. As many of you may be aware, the SAVE plan was an income-driven repayment plan that was introduced during the Biden administration in the fall of 2023, that for the vast majority of borrowers was going to be the most affordable repayment option available. The plan started facing legal challenges in April of 2024, which resulted in a court injunction being placed on the Department of Education in July of last year, which prevented the Department of Education from enrolling new borrowers in the SAVE plan or billing people at calculations based on the SAVE plan formula. And what happened is, as probably many of you participating in this webinar know, if you were in the SAVE plan at that time, you were placed in a forbearance, and that's where most SAVE borrowers still remain. This forbearance right now is scheduled to end on October 31st of 2025. However, it could be extended. It really is incumbent upon what happens with the court case, which is still ongoing. Time spent in the forbearance does not count towards loan forgiveness, either PSLF or IDR forgiveness. One of the key things that has changed recently about this forbearance is that it had been a non-interest-bearing forbearance up until August. Back in, I don't remember whether it was June or July, the department announced that they will begin accruing interest on loans in the SAVE forbearance starting on August 1st of 2025. To the best of our knowledge, at last report, there were close to 8 million people, about 7.7 million borrowers still enrolled in SAVE. Next slide, please. So the SAVE plan is eventually going to go away. Like I said previously, a court injunction is preventing new borrowers from enrolling in it now. And if it doesn't go away via the courts, it's slated to go away as a result of the OBBBA, the new budget bill. Just because they've restarted interest in the SAVE forbearance, however, does not mean that you have to leave the SAVE forbearance immediately. You can remain in the SAVE forbearance for now. If you're not ready to make payments, if you cannot find another repayment plan that you feel you can afford, you can remain in the SAVE forbearance essentially until it ends, which, as I said, right now is slated to end at the end of October. Or you can choose to switch to a different plan. You can switch to another income-driven repayment plan or a non-IDR plan. And you generally want to do this by visiting studentaid.gov. This is your federal student aid account at studentaid.gov, and filing an application to switch your plan online there. Just remember that when the SAVE forbearance does end, if you have not chosen a different plan, you may be placed automatically in the standard fixed plan, which for a lot of people can be an unaffordable plan, but you shouldn't panic if that happens. You will still have the option of enrolling in a different IDR plan or a non-IDR plan. Okay, next slide, please. So one of the big changes that's happening going forward is concerning and surrounds borrowing limits for federal student loans. Federal student loans, certain loan groups have always had borrowing limits, and we're going to go through what's changing, what maybe has not changing, and some of the more significant changes that will take effect on July 1st of 2026. So starting with direct subsidized and unsubsidized loans for undergraduate school, there are no changes to those borrowing limits. The current borrowing limits for a dependent undergraduate student would be, as a freshman, you can borrow up to $5,500. As a sophomore, you can borrow up to $6,500. Thereafter, you can borrow up to $7,500 per year. These are annual limits. with an aggregate of $31,000 total that you can borrow as a student for your undergraduate degrees. Now, here's where some of the changes start to come in. For direct unsubsidized loans for graduate school, if you're pursuing a master's degree, the annual limit is $20,000 and $20,500. That frankly is the current limit. But the aggregate limit on borrowing for master's degrees, so these would be things like, include things like PhDs and doctorates, would be a total of $100,000. This is over your lifetime. If you're pursuing a professional degree, so something like a medical or law degree, it's going to be a $50,000 annual limit and an aggregate lifetime limit of $200,000 for that specific degree. Graduate Plus loans. Now, the Plus loan program for graduate students allowed students to borrow up to the cost of attendance. So that would be the cost of the attendance of the school less whatever other aid they had received in direct unsubsidized loans for graduate students or in scholarships and grants. The Graduate Plus program allowed borrowers to basically fund their entire education within the federal student loan system. This program is actually going to be phased out for new borrowers starting July 1st of 2026. And what that ultimately is going to mean is that some people are going to need to find other avenues to fill the gap in terms of funding their education, particularly if they're pursuing expensive professional degrees. Now, there is a grandfathering clause attached with the phase out of the Graduate Plus loans. If an individual has received a Graduate Plus loan before June 30th of 2026 and is enrolled in a program of study, you may continue to take out Graduate Plus loans to complete your program of study, but up to a limit of no more than 3 years to complete that program of study. So you will be able to continue taking Grad Plus loans again if you have a loan dispersed prior to July 1st of 2026, and you can continue borrowing for up to 3 years to complete your program of study. But keep in mind, when you pay the loans back, you will have to pay the loans back under the new rules, which we're going to discuss in a minute. So Parent Plus loans function in a similar way to the Graduate Plus loans. Parent Plus loans allowed parents of dependent students to borrow up to the cost of attendance for their dependent students' undergraduate education. Again, this would have been basically unlimited borrowing up to the cost of attendance. The rules are changing, however. So going forward, starting July 1st of 2026, there will be an annual borrowing limit of $20,000 and a lifetime limit of $65,000 per child. And this includes borrowing between both parents. Again, there's a grandfathering clause with the Parent Plus loans. If an individual has received a Parent Plus loan for a dependence program of study before June 30th of 2026, they'll be able to continue borrowing Plus loans for up to 3 years so that their dependent student can complete their program of study. But once again, they will have to pay those loans back under new rules, which are even more sort of restricted for Parent Plus borrowers, which we'll talk about going forward. Next slide, please. Okay, so the repayment plans for future borrowers. So this is for anybody who takes a loan out on or after July 1st of 2026. You're only going to have two options for paying your loans back. You're going to have a new version of the standard fixed repayment plan. These are plans that base the payments on your loan balance, your interest rate, and a predetermined payback period. That payback period is going to range between 10 to 25 years based on the size of your debt. You make the payments in these plans, after which, when you make all the payments, you paid off the entire debt, including all the interest. Generally speaking, you do not get forgiveness when you're enrolled in a standard fixed repayment plan. And then there's going to be only one version of an income-driven repayment plan. And when I say income-driven repayment plan, or IDR, that's an umbrella term that covers a number of different plans, including some of the existing plans and this new plan called Repayment Assistance Plan, or RAP. So how is the payments in the WRAP plan calculated? They're calculated based on 1 to 10% of adjusted gross income for individuals that have an adjusted gross income above $10,000. The payment is going to be reduced by $50 for each dependent that you claim on your tax returns. There's a minimum payment of $10. So even if you have a very, very low income or no income at all, you're still going to be required to pay $10 per month towards these loans. There's a $50 a month, there's $50 monthly principal subsidy if your payment doesn't cover the interest and reduce the principal by this amount. Spousal income, if you're married, can be excluded when you're filing your taxes separately for the purposes of calculating the payment in the WRAP plan. And that's very important. It gives married couples a little bit more flexibility. There is no protected income or no adjustment for inflation in the WRAP plan, as there has been in some of the existing income-driven repayment plans. Now, one of the positive effects of the WRAP plan is that unpaid interest is not going to accrue. So this is similar to a feature in the SAVE plan. If your payment does not cover the interest that accrues on your loans every month, which if you have a large loan balance and a moderate to low income, it very often does not, that unpaid interest will no longer be added to your loan balance. So your loan balance may not go down, but you shouldn't be seeing your loan balances go up as long as you're making your payments on time and in full every month. This repayment plan is going to offer forgiveness after 30 years. This is longer than the existing plans, which offer forgiveness between 20 and 25 years, and it is eligible for public service loan forgiveness. Next slide, please. So this is just an illustration of what the new WRAP and income-based repayment plans are going to look like. The income-based repayment plans are currently exist. There is a modified version of these IBR plans that will continue to exist for borrowers who do not take out loans after July 1st of 2026. So some of you, if you are done with your borrowing, you may have the option of choosing WRAP or one of these IBR plans. And this chart just kind of gives you an idea of what the payments may look like based on your income. So you can sort of look at this at your own leisure at some point. But you can see that the WRAP plan does not have any limit. So there's no limit based on your income, whereas the IBR plans actually do have a cap on them. It depends on your loan balance and your income. The WRAP plan, by the way, is not available just yet. It probably will not be available until July 1st of 2026, maybe a little bit sooner, but possibly not until July 1st of 2026. Next slide, please. Okay, so we're going to go through this with different categories of borrowers, and we're going to start with repayment plans for student borrowers. So for existing student borrowers, and by that I mean anybody who's basically done borrowing before July 1st of 2026. These are people who will not be taking out new loans on or after July 2026, and you're just going to be dealing with your existing debt. You're going to be able to access payee, ICR, and IBR. These are all current income-driven repayment plans. Under the current rules until July 1st of 2028. After July 1st of 2028, any borrower who is not enrolled in the IBR plan, but maybe enrolled in payee or ICR, will be transitioned to a modified version of the income-based repayment plan. Now, these borrowers, by the way, will also have access to a standard repayment plan if they wish to pay their loans back that way. But in terms of income-driven repayment options, these are the current options: payee, ICR, and IBR through July 1st of 2028. Thereafter, it will only be a modified version of IBR. For new student borrowers, so if you're taking out loans for the first time on or after July 1st of 2026, or even if you're an existing borrower that takes loans out on or after July 1st of 2026, you're only going to have access to that standard fixed repayment plan. and the repayment assistance plan, or the RAP plan, which is the one plan that's going to be based on your income. And this is due to a rule that's in the budget bill that says that borrowers must pay all their loans back in the same repayment plan. So if you have existing loans that were enrolled in IBR, but you take out new loans that were after July 1st of 2026 that are only eligible for the RAP plan, you have to pay everything back in the RAP plan. Okay, next slide, please. Now we're going to talk about repayment plans for parent borrowers, because here's where it gets sort of significantly different from some of the current situations. So again, we're going to start with existing Parent Plus borrowers. These are people who will be done with their borrowing, will not take any loans out on or after July 1st of 2026. So a Parent Plus borrower is going to need to consolidate their loans before July 1st of 2026. And I mean fully consolidated, not just that you file the application by that date. You must have submitted the application, and the new direct consolidation loan must be dispersed by July 1st of 2026. So that means that basically you're going to have to start the consolidation process a couple of months in advance to make sure that you meet that deadline. So you're going to have to consolidate your loans first if they're not already consolidated. And you can select an income-driven repayment plan for which you're eligible prior to July 1st of 2028 in order for you to retain access to any income-driven repayment plans. Now, new guidance that came out from the Department of Education just literally in the last week is saying that existing Parent Plus borrowers are going to have to first, after consolidating, will have to first enroll in the ICR plan and make at least one payment in the ICR plan before transitioning to IBR, which in many cases can be a cheaper option than ICR. So I just want to say about this rule, it just came out last week. It's still being finalized. It is subject to change, so you want to stay tuned. There are, you want to consult the Federal Student Aid webpage. They just put up a new page about the One Big Beautiful Bill Act and some of the implications, and they're issuing guidance on that page. Now, for new Parent Plus borrowers, anybody who is borrowing their first loans on or after July 1st of 2026, these loans can only be paid back in the standard repayment plan, even if consolidated. So basically, new Parent Plus borrowers will not have access to any income-driven repayment plans. They're not going to have access to the RAP plan, and they're therefore not going to have any path towards IDR forgiveness or public service loan forgiveness. And here's another thing that we want everybody to understand because of that. Everybody has to pay back their loans in the same plan rule. If an existing Parent Plus borrower takes out any additional Parent Plus loans on or after July 1st of 2026, they're going to have to pay all their debt back in the standard repayment plan. There will be no access to IDR or forgiveness programs. So that means that Parent Plus borrowers are going to have to think very carefully about how they're going to go about funding their children's education, and to make sure that they don't borrow and borrow more than they can afford to pay back. Okay, next slide, please. Some other changes that are going into effect. So there's going to be changes to deferments and forbearance. So for loans that are dispersed on or after July 1st of 2027, they will not be eligible any longer for economic hardship or unemployment deferments that are currently available to loans that are dispersed prior to that date. And you can only be in a discretionary forbearance for 9 months over any 24-month period. So these are more restrictive deferment and forbearance options than are available to borrowers currently. Now, on the plus side, rehabilitation of defaulted loans. Rehabilitation is one of the methods of getting your loans out of default if you're in default. Effective July 1st of 2027, you will get 2 chances to rehabilitate a defaulted loan. Currently, you can only do that 1 time. And then we've got 2 other discharge programs: Borrower Defense to Repayment, BDR, and Closed School Discharge, CSD. Biden era rules that were put in place back in 2022 have been, the implementation of those rules have been basically pushed back to July of 2035. And in addition, these programs are currently facing, those particular rules are currently facing legal challenges. So So new rules that might have made it a little bit easier to realize discharge in these programs have been sort of pushed way off into the future. Next slide, please. So we always talk about, when we see our clients at EDCAP, we talk about the fact that people will very often come in and will have a specific issue that they need to address, whether they want to, they can't afford their repayment plan, or they're on the brink of going into default, or they're in default and they want to get out of default. And of course, we're always going to address those immediate issues. But one of the things that we want you to do is also leave with an understanding of what the strategies are for actually eliminating your debt, because at the end of the day, that's everybody's goal, is to just get rid of their debt. So with having worked with thousands of borrowers over the last 5 or 6 years, everybody falls into one of these 3 buckets. One possible strategy would be paying your debt in full as quickly as possible. So this may be best for borrowers who have low loan balances or high income relative to their balance. They have the ability to make extra payments over and above the monthly required payments, or even lump sum payments. If this is your strategy, the faster you pay it off, the more you're going to save in interest. And then you might want to consider one of the traditional repayment plans to complete this strategy. The second bucket, which is probably where the majority of our clients lie, and probably where a lot of you lie, is to identify a forgiveness program that you may be eligible for, and then make the minimum required payments until such time as you've achieved forgiveness by meeting all the requirements of that program. So again, this may be best for borrowers that have high loan balances, or high balances and low to moderate incomes. If you're pursuing a forgiveness program like PSLF or IDR forgiveness, it generally requires that you be enrolled in an income-driven repayment plan. Not always, but often that is the case if you're pursuing this kind of strategy. And then the last bucket, which sounds a little bit morose, but we have this here for a reason, is to make the minimum required payment until death do you part. So this is often a strategy that's used by older borrowers who maybe have taken late in life loans for themselves, or they have a lot of Parent Plus loans that they've taken for their children, but they're sort of either approaching or in retirement, so they don't have the option of pursuing a forgiveness program, and they may have to be repaying their loans for 20 or 30 years. And that could mean that you're repaying for the rest of your life. The idea here is to just find the cheapest repayment plan that you can and pay essentially until you die, or the rest of your life. And the reason that we put this here is because, unlike most consumer debt in the United States, forgiven balances due to death for federal student loans are dischargeable in death. And what that means is that your obligation to pay your debt does not accrue to your estate or pass down to your beneficiaries. So you're just choosing the cheapest repayment option until such time as you pass, with the understanding that this is not going to be a burden for your loved ones. Okay, next slide. All right, I want to say a couple of words about the IDR account adjustment, the income-driven repayment account adjustment. So IDR plans, as they were issued starting way back in the 1990s and through the early 2000s, offered forgiveness if you made a payment in those plans for between the original ones between 20 and 25 years. The WRAP plan, it's going to take 30 years to get IDR forgiveness. And this is a forgiveness program that does not have any employment requirements. So essentially, if you just have a very large loan balance and a low to moderate income, but you don't qualify for things like PSLF, this would be a potential forgiveness plan that you could, forgiveness option that you could pursue. The problem with this forgiveness program is that it was very, very poorly administered, and up to the point where the Biden administration implemented this account adjustment, almost nobody had received forgiveness in this program, even though these plans had been around since the mid-90s. So the Biden administration, through this one-time account adjustment, awarded credit towards IDR forgiveness based on a set of relaxed rules, which allowed many borrowers to accumulate credit or even get their loans discharged based on this one-time revision. Now, at the beginning of the year, there was an IDR forgiveness tracker on people's federal student aid accounts. That's been taken down, but the information is still in the system, and that tracker may be restored. So, we'll have to see when they eventually do put those trackers back up. But you understand that if you had direct loans or consolidated your loans by June 30th of last year, you may have credit towards IDR forgiveness through this one-time account adjustment. Now, IDR forgiveness credit accumulated in any repayment plan should be transferable to the modified versions of income-based repayment and to the WRAP plan going forward. Next slide, please. And of course, we always have to say a couple of words about public service loan forgiveness, just to remind everybody of the basics of this plan or this program. This program forgives debt after making 120 qualifying monthly payments. That's 10 years worth of qualifying payments while working an average of 30 hours per week for a qualifying employer. And qualifying employers are generally nonprofits and governmental agencies. There's a few more restrictions or and definitions of those things, which you can always go to the PSLF page on federal student aid to get a broader idea. But that's the basics of the program. You also must have direct loans, and you must generally be paying in an income-driven repayment plan. And all income-driven repayment plans qualify. So payee, ICR, IBR, in the future WRAP, and if you have made any payments in the SAVE plan, those all count towards public service loan forgiveness. I want us to go back for a minute to the employment requirements, just so you understand it's not about the job that you do, so you don't have to be a nurse or a teacher specifically, or you don't have to be a nurse or a teacher or a legal aid lawyer to qualify for public service loan forgiveness. You just need to work for an organization that qualifies as a qualified employer, and you need to work the prescribed number of hours per week. Forgiven balances in public service loan forgiveness are not taxable at the federal level or at the state level in New York. Other states may tax, so if you're listening from another state, you need to check your state rules. But forgiven balances at the federal level are not taxable, and that did not change with the new budget bill. Now, there is a program called the PSLF buyback program. Some of you may have heard of this. It's a relatively new program. It's really kind of only being implemented now. It allows you to purchase months that you spent in disqualifying payment statuses, like certain types of forbearance or deferments, including the SAVE forbearance. So though the time spent in the SAVE forbearance does not count towards forgiveness, you may be able to buy back those months that you spent in that SAVE forbearance. Now, there's some requirements for doing this before you're able to do it. Number one, you have to have 120 qualifying months of employment on record. That doesn't mean that you have 120 qualifying payments. It just means that you've got the record that you worked for your employer. You've met the employment requirements for at least 120 qualifying months. And then the months that you plan to purchase must get you to 120 qualifying payments in order for you to be eligible for the buyback. So even if you're not eligible for it right now, you may be eligible for it down the road. It's relatively simple to submit a buyback request. You go through the PSLF reconsideration portal through your federal student aid account, and you simply select the PSLF buyback application, and then you'll get, I think, a confirming message saying that they've received your request, and then you just wait for them to follow up with some kind of a letter. Now, one big caveat here is that the application processing for PSLF buyback is very, very slow. We've had some status reports as a result of a lawsuit where the Department of Education has been required to provide these status updates on processing for the buyback program to the public. And they're only processing a few thousand per month, and the backlog is growing every day. It could take quite a long time for them to get through the backlog. So that's one thing to consider. It doesn't mean that you shouldn't submit the application. It just means that it may take a very long time for you to hear back. Next slide, please. One of the things, though, that you can continue to do if you're pursuing PSLF is to submit your PSLF certification forms. These are the forms that verify that you've met the employment requirements of the program. And you must submit these forms in order for you to get official qualifying payment credit. You have to submit at least one form for every qualifying employer that you've had since October 1st of 2007. That's when the program started. So any payments that you made prior to October 1st of 2007 don't count. Or if your loans were dispersed after October 1st, 2007, you'd want to submit the forms from the time that your loans were dispersed. There's no deadline for submitting the forms, but the general recommendation is that you do it annually or whenever you change jobs, or of course, when you think you've reached 120 qualifying payments. You can use the Public Service Loan Forgiveness Help Tool. This is something that you can find on your federal student aid account. That's studentaid.gov, and request an electronic signature from your employer. The forms that are submitted in this manner are being processed relatively quickly. Things that are submitted with a manual signature or a manual document, an upload of that kind, are taking a lot longer to process. Next slide, please. So let's go through a little bit of guidance based on your repayment strategy. If your repayment strategy is to pay your loans in full, then a lot of what we talked about today probably doesn't apply to you, but some of it does. You might consider a traditional repayment plan. And again, the faster you pay the loan off, the more you're going to save in interest, but that of course will require making higher monthly payments. So you have to determine whether or not that's something that you can do. If you're pursuing income-driven repayment forgiveness, or IDRF, and as a reminder, this is the forgiveness program that forgives your debt after making 20 to 30 years of qualifying payments, if you include the RAP plan, in an income-driven repayment plan, and there's no employment requirement attached to that. For existing borrowers, you can select from one of three plans at this point: IBR, Payee, and ICR. Payee and ICR are going to be phased out over the next 3 years by July 1st of 2028. If you're still in those plans as of July 1st of 2028, you would be transitioned to one of the versions of the IBR plan. If you're pursuing public service loan forgiveness, if you're already enrolled in IBR, Payee, or ICR, you can continue making payments, and you're going to earn credit on your towards PSLF. Remember to submit your PSLF certification forms to update your employment. If you're in SAVE, you might consider switching to a different repayment plan. At some point, you will be required to switch. If you can afford one of the other payment plans, you might want to consider doing that now. In terms of selecting the RAP plan, now in some circumstances the RAP plan may be cheaper than the modified version of IBR, but it may also take you longer to pay the loan off in the RAP plan if you're pursuing IDR forgiveness, because remember, that's a 30-year path to forgiveness versus 20 or 25, depending on which IBR plan you're eligible for. The RAP plan is not available yet. We expect it to be available at the latest July 1st of 2026, maybe a little bit sooner, but like I said, at the latest July 1st of 2026. And then existing student borrowers can switch to the RAP plan when it becomes available. If you don't choose the RAP plan, by the way, if you stay in IBR, if you do choose, let me rephrase that. If you do choose the RAP plan at any point and you're an existing borrower, it's not clear whether or not you'll be able to switch back to income-based repayment. This is one of the things that they have to clarify while they convert the rules from the bill into regulatory text. The payments in RAP plan, though, will count towards public service loan forgiveness and towards IDR forgiveness. Next slide, please. So for Parent Plus borrowers, and we want to just reiterate that you may need to take some action if you're an existing borrower who is pretty much going to be done taking out your debt before July 1st of 2026, and you want to retain access to an IDR plan and forgiveness programs. Under the terms of the existing bill, you're going to need to consolidate your loans before July 1st of 2026. And again, that's full consolidation, meaning they have to be consolidated and dispersed before July 1st of 2026. So you're going to need to start that process several months in advance. And like I said earlier, the recent guidance says that after consolidation, borrowers must enroll in an ICR plan and make at least one payment before transitioning to IBR, if that's the plan that you ultimately want to be in. But again, these rules are in the process of being finalized, and they could be subject to change. Now, I do want to say another reminder that Parent Plus borrowers who take out any loans on or after July 1st of 2026, even if you have some existing loans, you'll have no access to the WRAP plan or the modified IBR plan. You're going to have to pay everything back in a standard plan, and thus you will not have a path towards IDR or public service loan forgiveness. Okay, next slide, please. Okay, we're going to talk on a couple of other programs before we wrap up and go to questions. Total and permanent disability discharge, TPD discharge, is a program that allows you to discharge your loans if you have a mental or physical disability that prevents you from earning a livable wage. And there are three ways that you can qualify for TPD. You can either qualify through Social Security if you have a certain type of Social Security disability status. You can qualify through the VA if you're a disabled vet and meet the requirements there. And if neither of those apply, you can qualify if you get a medical certification that states that you meet certain criteria. Now, the management of the TPD discharge program, which used to be managed by Nelnet, which is one of the loan servicers, was transitioned earlier this year to the Department of Education. So there's a new process for submitting the forms. You can do it online from your federal student aid account. If you look under loan forgiveness on the login page, you should be able to navigate to the TPD discharge page. You can file an application there. If you just Google TPD federal student aid, you'll also get a full explanation of all the rules and requirements of TPD. If you need help with this, you can reach out for help. The transition to this new process has met a few stumbling blocks, but they're working through it, and hopefully they'll start processing these applications more vigorously as the year goes on. Next slide. Okay, the last series of slides is going to focus a little bit on delinquency, default, and collections. So remember, during the pandemic and for a year after the pandemic, borrowers really didn't have to worry so much about delinquency, but you do have to worry about it now. So if you miss one payment, it basically means that you are delinquent. After 90 days of delinquency, essentially 3 months, the missed payments are then reported to credit agencies. So if you're experiencing delinquency, you might call your servicer and request what's called a retroactive forbearance, meaning they would apply the forbearance to the time that you initially became delinquent, which would bring your accounts current and could help you with your credit. They're not obligated always to provide these forbearances, but it can't hurt to ask. But remember, forbearances and deferments are short-term methods of obtaining payment relief. They're not long-term strategies for tackling your debt. So at some point, you are going to have to explore other income-driven or IDR options for more affordable payments and come up with an actual repayment strategy. Next slide. Okay. So what happens if you're delinquent for 270 days or more? So at 9 months, your loans are generally placed in default. And these are federal student loans. The rules for private loans are very different. You could wind up in default a lot quicker in private loans, but they're very different. This is just for federal student loans. After 270 days of non-payment or 9 months, your loans are placed in default. What that means is that the debt becomes payable in full immediately, which of course is generally a non-starter for most people that go into default. You're also not eligible for income-driven repayment plans, deferment, forbearance, and you can't earn credit towards forgiveness programs while you're in default. You also do not have access to federal student aid. And then at some point, you could also be subject to involuntary collections. Now, involuntary collections had been suspended on the vast majority of federal student loans for about 4.5 years since the beginning of the pandemic. The Department of Education announced earlier in the year that they were going to start collections again. It's hard to say exactly when that's going to happen. We've already seen some notices go out. It may speed up as we get towards the end of the summer and into the fall, but involuntary collections generally happens in 3 ways when it comes to federal student debt. They can do an administrative wage garnishment, which means they can deduct a certain percentage from your paycheck. They can intercept your tax refunds, or they can actually offset your Social Security. They can leave you with no less than $750 a month in Social Security, but they can take up to 15% of your Social Security. And these are all done administratively, meaning they do not have to take you to court. You will simply receive a notice, and then you will wind up having some of your income taken from you. Although they generally in the notices will give you a chance to respond to the notice, request a hearing, and maybe stave off the actual collections. If you do get one of these notices, you do want to respond very quickly. You can also call there's a phone number that we provided here. It's the Treasury Offset Program, or TOP hotline, which allows you to call. It's just a very simple call. You provide your name and your Social Security number, and they'll let you know whether you're scheduled for a Social Security offset or a tax refund intercept, which is what the Treasury Offset Program manages. Administrative wage garnishment may be managed in a different manner. We don't know. We're waiting to see how that pans out. Next slide, please. Now, the good news is that if you're in default and you have a federal student loan, there are actually ways to get out of default. There's 2 primary ways to do this. There is something called loan rehabilitation. You make 9 on-time payments in full over a 10-month period, after which your loans will come out of default. It will move to a non-default servicer, and then you're going to make arrangements with the non-default servicer to pay back your loans in an income-driven repayment plan or a standard repayment plan, whatever it suits you best. For this type of plan, you must work with the debt collector to get to start the process and throughout the process. It generally takes 10 to 12 months to complete, and it can be expensive depending on the payment that you're required to make over that 9 months. It does remove the default remark from your credit report if that's still on your credit report. Doesn't always remember federal student loan defaults age off your credit report after 7 years. So if your default is older than that, you may not see it on your credit report, but just because it's not there doesn't mean that you don't owe it. So it will remove the default remark from your credit, but the delinquencies that led up to that default will remain on your credit report until they age off. You will be able, if you do a loan rehabilitation, you'll be able to retain any accumulated credit towards forgiveness programs. It basically maintains the existing loans that you rehabilitate in their existing forms. The other option is loan consolidation, where you're just simply replacing the existing defaulted loans with new loans that are in good standing, and then you make the payments on your new loans based on the terms of those new loans. This application can be filed online. It generally takes 2 to 4 months to complete, and often can be done at no cost if you do it online. It doesn't remove any derogatory remarks from your credit, and there's a possibility that you could lose some accumulated credit towards certain forgiveness programs. Also, any unpaid interest that you have, if you consolidate, will capitalize, meaning it will be added to your principal. So we're not recommending one over the other. This is going to be tailored to what your situation is like. We do suggest that you seek advice if your loans are in default, so that you take the path that's best suited for you to get you back into good standing. Okay. And next slide, which I believe we're at the end. So I'm going to turn it back to Nipa.
Yes, thank you very much, Nancy, for those updates. I also want to make sure that you're all aware that you can request assistance with cases before federal agencies from your congressional offices. While our office has been able to get responses from the Department of Education and Loan Services, their response time has been severely delayed. But if you are a constituent of NY14, you can reach out to us through the QR code provided on the screen, or also the link that's provided here. My colleague will also drop a link to the website you can use to confirm your congressional district in the chat. And then, as promised, we will now move on to the Q&A. Those of you joining us via the Zoom platform may use the Q&A feature to submit your questions. When submitting your questions, please share your first name, neighborhood, as we will prioritize questions from constituents. So our first question is from Lisa. If we switch to a new income-driven repayment plan, will the payment be made in the past still count forward towards future loan forgiveness, or does this get reset? I have been paying my student loan since 2009 and only have a few years left to pay until I would be eligible to apply for loan forgiveness. I see my payment history has been taken down from my studentaid.gov dashboard.
So I think, Lisa, what you're referring to is the income-driven repayment forgiveness, which I did talk a little bit about earlier. The tracker that was on your account earlier this year, which has been taken down. So to answer your question, so this is the forgiveness program that offers forgiveness just by virtue of being in an income-driven repayment plan and paying for 20 or 25 years. You will not lose credit if you've accumulated credit, whether it's in the SAVE plan or the IBR plan or the Payee plan, ICR plan, and you switch to a different plan, including RAP, you will not lose that credit. And that information, believe it or not, is still in the system. So it's not visible to you, but it's there. So we do hope, we don't know when, but we do hope that that tracker does reappear at some stage on your website, so you'll be able to figure out and monitor your progress.
Thank you. Next question is from Rachel. Will the new bill affect Pell Grants? I'm eligible for a Pell Grant, but don't know if I'll get it with the new bill.
So my understanding, and I'm just gonna preface this by saying that I'm not as intimately familiar with the changes to the Pell Grants as I am to some of these other changes. My understanding is that there are some changes to the Pell formula. I can't give you the specifics. I'm not sure anybody could give you the specifics that might make it a little bit harder for people to get a Pell Grant. You're going to have to go through the process. There is, you can try the FAFSA estimator on the Federal Student Aid website. I'm not sure if it's been updated to factor in these new rules yet, but that might give you an idea of what you may be eligible for. And I also do know that they're extending Pell Grants for certain workforce development programs that were previously not eligible. So, but yeah, I'm not sure if the FAFSA estimator is updated yet with the new information, but you could try that as a start.
Great, thank you. The next question is from Pavel. Pavel asked, I applied for a switch from SAVE to IBR last November, and my application is still under review. Does it make sense to submit another one or wait if the first one comes through?
Yeah, so we're seeing a lot of this, and it's very possible that last November when you did this, for a long period of time, they weren't processing the IDR applications, and then for some period of time, they had disabled the online application and the automatic link to the IRS data retrieval system, all of which meant that a lot of applications that piled up had some kind of manual component to them. If that's the way you submitted your application, you might, at this point, if you haven't gotten a response, it might make sense for you to go back online. The IRS data retrieval tool, which basically pulls in your income from the IRS database during the IDR application process, that's working now, and not in every case, but it's working in many cases. And if you could submit the application using that feature, you might get the application processed quicker. I also want to mention, for anybody here who's listening, if you submitted an application to enroll in the SAVE plan, or on the old applications, if you selected the box that said, allow my servicer to select the cheapest repayment option, those applications are not going to be processed. The government has actually said, we're not processing these applications. I don't know if the servicer is going to actually let you know that. But if that's the way you submitted the application, because of course you can't enroll and save now, and they want you to pick a specific IDR plan, you do need to resubmit an IDR application at this point.
All right, and the next question is from Christina. Will IVR and other IDR plan payments count towards REP when it has started?
So I think, I'm assuming you mean when it comes to income-driven repayment forgiveness. Any payment that you make in any of the existing IDR plans would count towards the RAP, towards forgiveness in the RAP plan if you switch to the RAP plan. I think that's what that question was getting at.
Okay, and the last question is from James from the Bronx. James asks, my daughter is starting 11th grade in September, which means I need to start getting ready for college. With the new rules coming into effect once she began college, are there any other programs beside applying for grants and scholarships to start putting some money aside for college besides a saving account?
Well, there are, I mean, you may be familiar with the 529 accounts, which is maybe what you mean by savings accounts, but 529 accounts are a tax deferred and eventually tax-free vehicle if you put the money into them and use the money for qualified education expenses. In terms of, I mean, it's mainly the main way you pay for college is your own family resources, loans, or scholarships and grants. This may apply to you as a Parent Plus borrower more than for a student borrower. One of the things that you may consider is there's a limited number of New York State programs that offer forgiveness on loans, but that's not necessarily scholarships or grants. I think they do have some limited scholarships and grants that are offered through New York State. That would be on the HESC website, HESC. Or if you're, for a student, if you're trying to pay back student loans and you're working with at a company, you might see if the employer has any either matching options where they match the student loan payments, or some employers and some unions even pay for employees to go back to school to earn a master's. I'm not sure that exactly answers the question that was asked, but it's generally going to be loans and 529 savings accounts, other family resources, scholarships, and grants.
Well, thank you so much, Nancy, and the entire EDCAP team, our co-sponsor for this event. This brings us to the end of our webinar. If we didn't get to your question and you are a resident of NY14, please email us at aoc.townhall@mail.house.gov or call us at 718-662-5970. You can also reach out to EDCAP using the contact information on the screen. A big thank you to our interpreters as well from Sign Nexus. And thank you all so much for joining. I hope you all have a great evening. Afternoon, sorry.
Can I just add very quickly, we are at EDCAP going to have a follow-up webinar on September 25th at noon. For anybody that didn't get their questions answered and wants to hear this repeated, you can register on our website, edcapny.org, for that webinar on September 25th.
Great. Thank you so much.
Thank you, everyone.
Have a great afternoon, everyone.